Chris Ann Hall describes how Iowa Supreme Court has refused to accept U.S. Supreme Court's decision on search and seizure. This is a good one.
This is Chris Ann Hall at the Chris Ann Hall Daily Journal. I am Chris Ann Hall, and I'm here with my husband and co-host, J.C. Hall, and I have a good court story for us today.
Awesome.
An amazing good court story today. The Iowa Supreme Court. Now, this is from an article at Forbes written by Nick Sabilla, and I think that, which may be Sabia? I don't know. Could be Sabia. Anyway, which is a huge 10th Amendment victory. So the Iowa Supreme Court, now he says ruled, but we know courts don't make rulings, that impounding a car and conducting an inventory search without a warrant violated Iowa Constitution's protection against unreasonable searches and seizure. Although the Iowa Constitution's provision is similarly worded to the Fourth Amendment of the United States, the Iowa Supreme Court decided, look at this, to, quote, stake out higher constitutional ground, end quote, and, quote, reach from current United States Supreme Court precedent under parallel provisions. And I just think this is absolutely amazing. This justice, writing for the majority, his name is Justice Brent Appel. He says that the article says that he repeatedly chastised the U.S. Supreme Court within his order, seeking, quote, to minimize the scope of individual protection under the Fourth Amendment. So what we have here is a Supreme Court Justice, Brent Appel, in Iowa, saying exactly what we have been teaching for 8 years, that the Supreme Court has gotten the Fourth Amendment wrong for decades. And what the Supreme Court of Iowa says is, look, you can't create excuses to circumvent the Constitution. You have to follow the law. And the law says if you're going to search someone's property, you have to have a warrant. The Fourth Amendment, he says, the Iowa Supreme Court says that the Iowa's Constitution mirrors the Fourth Amendment of the United States, and our Fourth Amendment of the U.S. says the right of the persons to be secure in their persons, houses, papers, and effects against unreasonable searches shall not be violated. No warrant shall issue but based upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. Period.
Yeah.
There's no exception. When we teach the Fourth Amendment class, we show there's only one exception to your right to be secure in your persons, houses, papers, and effects. By the way, that word effects is the catch-all. That means everything, right? So the only exception to your security in your persons, houses, papers, and effects there's only one exception. And that one exception has 5 criteria. You must have a warrant that is based upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. That word "and" there means all 5 things have to be present at the same time in order to have a reasonable search and seizure. And what we have here is the Iowa court saying, yes, that's what this means. The Iowa Supreme Court saying, yes, that's what this means. When will the U.S. Supreme Court recognize that the words mean what they say?
So, that's good news to my ears. I hope it is to everyone else's, particularly Dwayne Stovall.